Hi, welcome to the discussion on Chapter 9's The Jury. This chapter, we're going to be talking about trial by jury and how it developed, what are the rules, how do we get juries, and what are the jury's, guidelines that they have to follow in determining the guilt or innocence or punishment during criminal trials. So first thing you have to consider is the trial by jury is very much an integral part of the American criminal justice system. If you were just to go directly south from El Paso, Mexico does not have jury trials the way we do. The majority of their cases are resolved by both sides submitting written documentation and the judge or judges reviewing the written documentation and making a ruling based on that, rather than having live witnesses, and also rather than having regular citizens decide the fate of one of their own. What about the history of jury trials? Juries really originated in ancient Greece and Rome. And you've seen jury trials throughout the centuries in various parts of the world. In fact, at one point, you even had something called trial by ordeal, in which the person accused, or the defendant as we know them, would have to do something dangerous. And then if they survived, those that had accused them would assume that God intervened because the person was truly innocent, and that is why they survived. You've seen it at all points in our history. It's very prominent with people being accused of witchcraft and with other crimes as well. If you watched Game of Thrones, you might be familiar with trial by combat, so I thought this meme was rather amusing. If you didn't watch Game of Thrones, ignore it. It'll take too long to explain. Let's talk about a little bit more of the history. In Magna Carta in 1215, this dealt with the English justice system, and it is England's first mention of the right to a jury trial. And again, if you remember, Magna Carta was one of the first written limits on the power of kings in England. And so this was just another way to check the system or the powers that be. And why did this occur? Well, really because of the distrust of government. And because of that, juries were given a rather broad independence. As we'll discuss later on, juries' powers to decide cases are pretty much virtually unchecked, and they can pretty much decide a case however they choose. U.S. history of jury trials first starts with Article 3, Section 2 of our Constitution, which mentions that criminal trials shall have a right to a jury. Our Sixth Amendment also confirms that right with the right to jury trial, but the details are rather vague. Now, we also have the right to a speedy trial and some other rights regarding jury trials, and really what that means is not what's written in the Constitution, but what's been decided through case law since the inception of our country. What is the role of the jury? Well, first and foremost, juries have almost unlimited discretion and direction. I mean, they are given direction, they're given a jury charge, but what happens in the jury room is pretty much a mystery because only the jurors are allowed to deliberate, and we're not allowed to record them. Trust me, I would love to get a camera and record jury deliberations, just to not only to satisfy my own morbid curiosity of what they base their decisions on, but really, as an anthropological, study to see why it is, at least in my opinion, why do they rule the way they rule? Why, when people are, I think individually, for the most part, intelligent and have common sense, but sometimes when you put them together, why are they typically led by one, or lacking in common sense, or forgetting what they saw? But in any case, it'd be very, very interesting to see why juries ruled the way they do. And so when I say they have almost unlimited direction and discretion, it's because that's true. No one watches them. No one tells them you have to deliberate on these things. Well, I guess that's not true. The judge gives jury instructions and they're told what they can consider and what they can't. But no one is there during jury deliberations to ensure that that's what they actually discuss, or that that's what they actually base their decision on. They're really unchecked. Once they go back to deliberate, we really don't know what occurs. Okay, so what's the role of the jury? They are really the finders of fact. Remember when we talked about the judge? The judge can be not only the finder of fact, but the decider of the law. The jurors, really, their job is to listen to the facts and to take the law that the court gives them in the form of jury instructions and apply the facts to the law. That is their job. Okay. Jurors are not allowed to hold it against a defendant when the defendant decides not to testify. So a person has a Fifth Amendment right not to testify. I'm sure you've all heard the common phrase, "I take the Fifth." That means that the person is choosing not to incriminate himself. And jurors are prohibited from using that in their consideration. Now, I think as human beings, we really want to know both sides of a story, especially if any of you in the class are parents, or even if you're not parents, if you have younger siblings and they get into a fight, the first thing you want to know is what happened, and you want to separate them and say, okay, what's your side of the story? All right, great. Then you go to the other one. Now, what's your side? The Fifth Amendment allows a person accused of a crime to not say anything, and then the court tells the jury, you are not allowed to consider the defendant's silence when determining his or her guilt. Now, whether or not they actually listen to that, we don't know. Why? Because we can't go back in the jury room and hear deliberations. Jurors also get to decide possible punishment. Not always, but if the jury is chosen by the defendant in some states to decide punishment, that they can. But again, they can't use a person's lack of testifying against them, either in guilt, innocence, or in punishment. Now, jury instructions, jurors will be given jury instructions, and that is the law of the case. It's going to tell them what are the rules. What are the rules that they should follow when deliberating? It's also going to explain what the law is. For instance, if the defendant chooses not to testify, then that is a fact that cannot be used against the defendant. It's going to state that the government has to prove the case beyond a reasonable doubt. Now, there used to be a definition of beyond a reasonable doubt that was put in the jury instructions. Through court cases, we no longer have that definition, and beyond a reasonable doubt is left up to the common sense of each and every juror. Okay, but the jury instructions will also include the charge. Let's say they're charged with assault. It'll say something like, if the state proves beyond a reasonable doubt that on or about a certain date in El Paso County, Texas, that the defendant caused bodily injury to the victim by striking the victim about the head with defendant's hand. If you find the above, then you will find the defendant guilty as charged. If you do not find, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Now, also in the jury instructions, they'll also have an explanation of defenses. So for assault, an affirmative defense of assault is self-defense. It'll say, it'll go through what I just said, and it'll also have another paragraph that says, but if you also find that the defendant acted in self-defense when striking the victim about the head with his hand, you will find the defendant not guilty. So it's going to be kind of like a roadmap of what they're supposed to do. And jury instructions, for the most part, are written down and provided to each and every juror. What are the limits on right to jury, on right to trial by jury? Well, originally, the Bill of Rights only guaranteed that right to persons charged with a federal crime. Now, we know, based on selective incorporation, that the Bill of Rights was eventually passed on to the states, and that it now applies to the states. And it was expanded by the Warren Court in the 1960s. So since the 1960s, any person accused of a crime is entitled to a jury trial. Now for petty offenses, there's no trial by jury. Petty offenses typically are offenses that do not end in jail. Now some states allow it. For instance, Texas will allow you to have a jury trial for a petty offense. So if you get a speeding ticket, you are entitled by law to have a jury trial for that speeding ticket. Let's talk about jury size and unanimity. Let's talk about jury side and unanimity requirements. So does it have to be unanimous? Jury size. Every state is different. For the most part, you're going to have 12 people chosen for a jury. In Texas, you have 12 people for felonies and 6 for misdemeanors. Now, it is not permissible to have fewer than 6 jurors. In Texas, you will have 12 for felonies and 6 for misdemeanors. Unanimous verdicts are traditionally what is required. Okay, and why? Well, it legitimizes minority votes. Rather than having to convince a majority, the government has the burden of having to convince everyone on that jury. It's a safeguard for the defendant. And unanimous verdicts are required in most states, just as most states require at least 6 members. Well, how do you select jurors? Well, first, you've got to think about, why do we even have jurors? Why do we have jury trials? Well, the whole goal is you want to get people that are like the defendant, that are citizens. You want a fair cross-section that can relate to the defendant. You want people from within the defendant's community to pass judgment. And you also want people who are unbiased. And what do I mean by unbiased? I mean that you want someone who doesn't have an axe to grind, that isn't going to find the defendant guilty for a reason other than the government proved it beyond a reasonable doubt. So how do you even get to being able to pick a jury? Well, you've got to have a master jury list or a jury wheel. And these are any potential jurors within the jurisdictional boundaries of either the city or the county. It used to be that you had a key man system where you would have the leaders of the community that would select juries. Now, for the most part, it's random. Anyone who has a driver's license, voter registration card, they are put into a jury pool. So just a note for those of you that don't want to serve on a jury, make sure that your name on your license matches that of your voter registration card, because if it doesn't match, you're going to be entered into the system 2 times. That happened to my father-in-law, and he hated jury duty. All right, so jury selection now is pretty random. People get put into the system and they're drawn at random, and if you serve or you go to jury duty and you actually sit through the voir dire, your name is put at the bottom of the list. There are some exemptions for selection. So some places, if you are a politician, you don't have to serve as a juror. Same thing if you're law enforcement, or if you're a judge, or if you're a healthcare professional. Some states have exemptions. Some states have exemptions for sole caregivers, child care, elder, you're taking care of, a special needs person, attorneys. And let me go back to let me go back up to political office holders, law enforcement, judicial officers. I'm not sure that I agree with that. I think that if you're going to have a jury of your peers, you really should be able to call on anyone. Imagine having a jury trial where you're never going to get a doctor on the panel. I don't agree with that, and I really don't think that's fair either. Attorneys, as an attorney, I really don't want another attorney on the panel. However, I do think that attorneys should be called. And there's been times when I've had jurors on my panels and I've struck them. Mainly because I don't want anyone second guessing what I'm doing in trial. That's typically why most attorneys don't like other attorneys on their jury panels. Active military oftentimes are given exemptions, especially those that can be called out and that will not be in town to finish the trial. There are other exemptions like clergy, teachers, journalists, mariners, people that are on fishing boats, accountants, and other individuals with specific religious designations. Panel selection. So how do you get a particular panel? Well, jurors are chosen from the master jury or from the main pool, and they are told to show up for court, and they are then assigned to a jury panel. And those people are sent to a particular court and that whole panel, and they will be in that particular court as the jury pool or the jury panel from which the jury will be chosen. Just to give you an example, in a typical misdemeanor case, you'll have around 30 jurors that make up that jury panel, and from that jury panel of 30, 6 will be chosen for the jury. Felonies, you need a little bit more because people tend to have biases towards certain kinds of felonies, and so you want to have more people so that you have enough left over after people have been struck for various reasons to pick your panel. So for like a sexual assault, I would always request about 120 people for a sexual assault. If it's a regular felony, like a robbery, a burglary, something like that, I'd say 60 to 75 is probably good enough. Murder, depending on whether or not it's a high profile, you could have several hundred jurors. Okay, so let's talk about voir dire. So once you get the jury panel and the jury panel goes in to the courtroom, they are going to have to listen to what's called voir dire. Now, I say voir dire because I'm in Texas. It's actually not pronounced voir dire. The correct pronunciation is voir dire, and it means to speak the truth. And really what you're trying to do, or as an attorney, what you want to occur is you want to find out which jurors are going to not be biased and be fair for the case. Okay, I guess that's really not true. As an attorney, you want to find the jurors that are going to be best for your side of the case. But I guess in general, you want a jury to be unbiased. And so the process of voir dire is for either the judge, the attorneys, or both to speak to the jurors so that they can question them and they can question them under oath and find out whether or not these jurors can be fair and impartial in trial. Now, your book separates voir dire from the rest of the trial process and consider it really its own thing. I disagree. I think trial is a three-part process, beginning with voir dire, then the actual trial with the guilt-innocence phase, followed by punishment. So in my mind, I see trial as a three-part procedure. Your book kind of separates it out a little bit, but when you hear me talk about trial, I include voir dire in that because really that's the beginning of the trial. You're picking your jury. So the point is really to get unbiased people. So how do you find out about it? Well, you got to ask them questions. And there are two ways you can get, and I guess I better back up. Picking a jury is kind of a misnomer. You don't really pick a jury. No one picks a jury. What the attorneys or the judge, whoever's doing the questioning in the case, what they do is they strike people from the panel, either because they're biased or they just don't like them. And that's called a peremptory challenge. We'll get to it in a second. And then the people that are left over, in Texas, if it's a misdemeanor, you'll take the first 6 people that are left over, and that's your jury. Felony, it'll be the first 12. So if you get called to jury and you're seated towards the front, you have a better shot of getting on the jury than those sitting in the back. So really what I want you to take away from this is that voir dire or jury selection is a deselection process. The attorneys and judges are getting rid of the people that they think are biased and won't be a good juror, and then whoever's left over, that's who gets picked. Okay, so how do you get rid of people? Well, you got 2 ways. You've got a challenge for cause and peremptory challenges. Challenge for cause is striking someone because they cannot be fair. Either they're not going to be fair to one of the parties, the defense or the state, or they're not going to be fair because of the law. Or maybe they have a bias against a witness or a class of witnesses. You know, some people will say, if you put a police officer on the stand, I will believe them no matter what. Others will say, I don't believe police. Whatever they say, I think they're lying. Some people will say, you know what, this is a sexual assault. I know someone who is sexually assaulted, or I myself was a victim, and I cannot be fair or impartial. So you have to talk to the jury and try and find out, are they going to be able to listen to the evidence and make their decision based solely on what they hear in court and not based on their own prejudices. So a challenge for cause. If someone goes in there and says, you know what, I really can't make a decision because of my religious beliefs, then they're going to be struck for cause. If someone says, you know what, if a person gets arrested and they're here before us, then they're clearly guilty because the police aren't going to arrest somebody who's not guilty, and the prosecution's not going to go through the process of prosecuting someone if they're not guilty. Okay, that clearly they're not there to hear the evidence. They've already made up their mind. So that would be a valid challenge for cause. You know, another challenge for cause that I would see a lot are drug cases. There's a lot of people that believe that marijuana should be legal here in Texas, and they refuse to find anyone guilty if that person is before them on a possession charge. So those are all things that are important to ask, and those will go towards a challenge for cause. Now, peremptory challenges can be used, they're like a free strike. You know, maybe the person's wearing a Red Sox jersey and you don't like the Sox. So you're like, you know what, strike them. Or maybe they're reading a book that you don't like, which I will tell you, I've struck people based on the books that they would read or bring, you know, because I made a judgment call and determined they were either going to be too liberal or too conservative for whatever case I was trying. I also don't like engineers on my jury. Just from past experiences, I tend to prefer to not have an engineer on my panel. I typically like teachers. Teachers, I think, make pretty good jurors. But I have friends that are prosecutors that really don't like teachers on panels. So it really just depends. Everybody kind of has their own thing. And you can pretty much, as an attorney, you can strike someone for any reason. You don't like what they're wearing, you don't like the way they look, you just get a bad feeling about them. There's only two things you can't strike them for. One, their race, and the other, gender. That is illegal. You cannot strike someone based on their race or gender. If an attorney does that and the other side believes that's what they're doing, they can file what's called a Batson's challenge, and they will have to prove to the court why they struck that juror. And they'll have to come up with a reason that's not based on race or gender. Now, sometimes it's pretty obvious, if one side's striking all the women or they're striking a certain minority, you can kind of see. But it's not that easy to prove typically. Okay, moving on. Let's talk about reforms to the jury system. So what changes have been made since we started having regular juries? Well, really, it kind of began in the 90s. There were multiple reforms. First one was allowing jurors to take notes. It didn't used to be allowed because some jurors couldn't read or write. They were illiterate. And they didn't want those that could read or write to say, well, I took notes, and according to my notes, this is what was said. And they didn't want those literate jurors to dominate. Now, most courts allow people to take notes. The danger in it is that people will take notes, not exactly what they hear, but how they interpreted it. And so they're going to get some, maybe a little bit of bias in their notes. And sometimes it's not intended. But how many times have you heard what someone said and you tell someone else, and that's not exactly what they said, but it was the way you interpreted it? And so, I can see how notes could be an issue, but I think for some cases, especially when you have really long trials, notes are a good thing. Jurors are also allowed to question witnesses. In some cases, these are called master juries, and jurors are allowed to send questions to the court to ask the witnesses. It allows them to gain important information that's relevant to the proper witness. And those questions are submitted to the judge, and the judge will read the question. Texas typically does not do that. Jury instructions. Jury instructions are written copies of the instruction for each juror. They are written typically on about a 6th grade level. They've got to be easy to comprehend, and they are read aloud to the jury. So after each side rests and closes and have presented their, or before closing arguments typically, the court will read the jury instructions and then allow the attorneys to make their closing arguments. Okay, and the jurors typically will have a written copy to follow along with as the judge reads it. Some courts also have trial notebooks, and these notebooks have the jury instructions, witness lists, the exhibit list, certain photographs. I have never seen this done here in Texas. I think these are probably reserved for, your very high profile and long cases where you have numerous witnesses, hundreds of exhibits, things like that. Here's the stats on the reform to the jury system. You've got close to 70% of jurors that are allowed to take notes in most jurisdictions. Very few, 6% jurors are given the notebook. About 14% jurors are allowed to ask questions. About 70% are given the copy of the jury instructions. And really, all jurors given copy of written instructions, only about 33. So some courts just give one copy for the jury to share. That's, I think, problematic because If a person is listening to something and they're reading it, you're reaching most people that are visual and audio learners. And most people really are visual or audio learners. So you're really hitting the high points with those jurors. If you only have one copy and people have to just listen to the instructions, you're going to lose your visual learners. How have these jury reforms been used? Well, it's kind of been a mixed level. Not every state has done this. If you go back to the stats, a third of jurors can't take notes. 1/3 are not given written instructions. So really, these jury reforms have really been kind of implemented sporadically and have not been across the board. It's very state specific. Let's talk about jury nullification. When we talk about the power of a jury and that their power is generally unchecked, that's really true. They are given a jury charge and they're read a jury charge that tells them what the law is and what is required of them and how they're to go about doing it. When they get back in the jury room, they can absolutely ignore it. And that is jury nullification. Jury nullification is a jury refusing to apply the law, and it's unreviewable. If a jury nullifies a case, and you see it, you know, the attorneys know when one side has proven the case beyond a reasonable doubt. And sometimes the jury just doesn't care. They don't want to find the person guilty. And it's unreviewable because to try the person again would violate double jeopardy. The only thing that can happen is the person's acquitted. And juries really are supposed to be a conscience of the community. And, it's not a bad thing. Let's say I'll just use this example. Let's say it's a juvie case and you've got a brother and sister, 10 and 11, and the 10-year-old slaps the 11-year-old because the 11-year-old broke the 10-year-old's toy. That is an assault that could be charged and tried. So let's say that case was charged and tried. And really all it was a slap. The younger sibling got mad at the older sibling for breaking his toy and he slapped him. Is that the kind of case we really want to prosecute? We could. We could prosecute that because that is technically an assault, and persons 10 years of age or older can be prosecuted in the juvenile system. I could see a jury nullifying that, saying you're wasting our time. This is silly. Siblings fight. You see it in drug cases. I have seen it in some of my cases. One case that I had that I will never ever forget was an assault family violence case. And I won't give you the facts just in case you know this, but it was very obvious at the end of the trial that the defendant had beaten his wife. And I got him to admit it on the stand. The jury found him not guilty. Yeah, let that sink in. He admitted it on the stand. There were visible injuries. We had good photographs, good evidence. The jury found him not guilty. Why? One of the jurors had a sister, and that sister was in an abusive relationship. And he and his family had tried everything to get her away from the abuser, but she refused. And the sister would get beaten up, she would leave him, and then she would go back to him. And this happened over and over. And the man who was on the jury, her brother, was very angry. And he convinced the rest of the jury that, and this came out, that my defendant, this wasn't the first time he had hit his wife. So he convinced the rest of them, this is an intelligent woman with means. She could leave, and she's not doing it. And he convinced the rest of them that it was her fault. And to this day, that case still bothers me. But it is very much a clear example of jury nullification. They were told in their jury instructions that if they believed that the defendant caused bodily injury to the victim and that they believed it beyond a reasonable doubt, they were to find him guilty. When I spoke to the jury afterwards, they said they believed he did it, but she should have left him. That is nullification. Nullification can be good, and in my case, it was bad. It was bad because oftentimes victims of family violence don't have the strength to leave their abuser. It's called a cycle of violence for a reason, because it's cyclical. You have an abusive event, then there's a falling out period, then they start making up, then they're in the honeymoon period again, and then there's another assault. And it just keeps going round and round until the cycle is broken. But unfortunately, if any of you have studied this or have any experience with this, you know that it is a very difficult cycle to break. Ladies and gentlemen, that's all I have for you today. I hope you all have a great rest of your day. Thank you.